Wine Industry Network's 2024 Bold Prediction Series is presented by Heffernan Insurance Brokers, with supporting sponsors Protea Financial, Turntine Brokerage, and American Ag Credit. Thank you for your support.
Hi, Liz Bishop
and Deborah Costa
here from Heffernan Insurance Brokers, and we are your fire mitigation and insurance
gurus.
This wildfire structure protection unit is a unit that the British Columbia government has been utilizing for about 10 years. And in 2023, there were 500 structures that were saved by this unit. So it has proof of concept.
Here today, we have Adam Iveson from Ember Defense to share with you a few important notes about this structure.
So this is a structure protection unit. This has everything on board to be self-sufficient. This has pumps, sprinklers, hose lays, bladders, everything to be off the grid to protect your property ahead of an oncoming wildfire.
Liz and I, in partnership with Ember Defense, are committed to protecting your winery property. Just think, if everyone invested in a wildfire protection unit, together we could ensure that wineries don't burn and make insurance affordable again. Text WASP Demo to 707-789-3062 for a free demo on your property.
Hey everyone, George Christie with Wine Industry Network. Welcome to another session of our Bold Predictions webinar today. We're here to talk about new regulations impacting the wine industry, and obviously we spend most of our time talking about what's happening in the vineyard, what's happening in the cellar, what's happening in the market. But there are new regulations from an HR perspective that are just as important as some of the things that have to do with making our wine and selling that wine. So today we're really happy. We've got Trish Griffiths. Trish is the senior HR consultant with the Personal Perspective, and Trish is going to talk to us a little bit about some of the new regulations impacting the wine industry that you need to be paying attention to. Before we get Trish on the virtual stage, I want to thank our sponsors again. Our presenting sponsor, Heffernan Insurance, along with our supporting series sponsor. We've got Protea Financial, Turntine Brokerage, as well as American Ag Credit. Trish, welcome.
Thank you. Thanks for having me.
Appreciate you joining us today.
Yeah, it's great. And thank you all for being here.
So once again, just as a reminder to everyone in our audience, we pre-record these a few days in advance. We do that for quality purposes, but it also allows us to engage with our speakers while the presentation is going on. We don't have to wait till the very end like we typically do in an in-person conference to ask those questions. So Trish is watching this broadcast right along with you. So as questions come to you, go ahead and submit those into the chat feature, and Trish can pick those off as they come in. So please take advantage of that. Trish, why don't I go ahead and I'll hand it off to you and let you take it from here.
Great. Thank you, George. I really appreciate it. Hello, and thank you. The Personnel Perspective is so excited to participate in your wine industry session this time around, and I hope the information provided will be useful. Just a little bit about us. The Personnel Perspective has served Sonoma and Napa County for a long time. We have a Santa Rosa office currently, and we've been providing full service human resources consulting for about 35 years. So we have a brief update for you today regarding some of the human resources legislation over the past year or so. It's a high-level view. It's not going to include everything. And of course, because it's a high-level view, if you have further questions, it may be necessary for you to reach out to a human resources professional or even an attorney if needed. With that, I'll get started on California employment updates impacting you. So topics we're going to cover today are in categories, all HR related, relating to hiring, onboarding, safety, time off and protected leave statuses, meal and rest breaks, which is very important. It can be an expensive mistake to make, so we'll go over that a little bit. And we have some wage and hour updates to provide to you. And we want to talk a little bit about NDA, that's non-disclosure agreements, and confidentiality provisions. So hiring in HR has become more and more complex over the years, and California in particular and federal hiring regulations are controlled by a variety of civil rights and privacy legislation. These impact our hiring practices and require that we modify our practices and forms on occasion. If you haven't reviewed your company application form recently, we really recommend it, and it's a good time to do that. And I'm going to go over a few of the things that are important right now. Okay, so hiring obviously starts with a conversation and sometimes an application form. And changes to the civil rights protections in California limit our employer access to information that is obtained on our application form. The first and foremost I want to bring up with you is that we should not ever ask for conviction history on an application form. This is not something that we're allowed to review until after a letter of offer has been proffered. So if you haven't given an offer letter to someone, I would not ask the question about conviction history. And this kind of also has some limitations in the background processes as well. So even after you've given an offer letter and you're into background investigation time, you don't want to review any criminal history that's more than 7 years old. If a criminal conviction is found, employers should be aware that that history may not disqualify them from the job, especially if it doesn't relate to the work that's being done. And I'll give an example. So for an individual that you're planning on hiring that does not require driving and is really doing manual labor for you and doesn't have access to a lot of information or other things, it's not a disqualification that they have a DUI. So if you do see a criminal history involved in your background investigation, I do think you should ask for advice from an HR professional or an employment attorney, if that makes sense to you, before making assumptions that they can't do the job that's presented before them because of the criminal history. Going back to the application form, it's also not allowed at this point to ask for social security numbers or the age of a candidate. Requesting this information puts you at risk for discrimination suits and complaints, and also potentially leads to a hiring bias by your managers. The reason that they went in this direction is, I believe, as an avoidance of age discrimination in particular, as well as possibly some discrimination against folks that maybe don't have a social security number quite yet or in the process of getting one. In addition to what I've mentioned before, I also would like to talk to you about, go back again. In addition to what's already been mentioned, we don't want to ask about prior salary or gender information on our applications. A recent addition to our legislation, SB 1162, is a Wage Transparency and Equity Act, as well as our Civil Rights Act protections, really protect employees and candidates from gender-based salary discrimination and inequity. Asking for prior salary perpetuates a history of inequity. As women and minorities have traditionally been paid less, former wages paid do not always reflect the value of the experience or the education of that applicant. If you have over 15 employees, SB 1162 also requires that you develop a wage pay scale range. The pay scale range really helps to avoid biases and inequities as you're reviewing current salaries, as well as any increases to salaries. It also needs to be available to employees should they ask for that information, and that's part of the transparency portion of the Act. So a good salary range really does a lot to protect your organization from bias, as well as complaints against discrimination. Let's talk about cannabis use. That's been on the mind, and we know that it's a big part of our California businesses at this time. So California has enacted AB 2188, which offers individuals some protections for discrimination against off-duty use of cannabis. Employers should be aware of this, but it's also impacting not just the current employees, but how we recruit for and hire employees as well. So again, AB 2188 protects candidates and employees from discrimination of off-duty use of marijuana. It doesn't mean that you can't enforce against a drug-free work environment. You are federally mandated to have a drug-free workplace environment. And if you don't yet have a policy for a drug-free workplace environment, please feel free to reach out to us about that. Policies written prior to 2024 should be revised to clearly separate the off-duty use of cannabis from on-duty use of cannabis. That's important for a number of reasons. One is the hiring practice, as well as just in terms of disciplinary practice with your employees on an ongoing basis. So during the application process, we don't want to ask about marijuana use. It's off limits, just like the conviction history. If after an offer letter is proffered, we are doing a pre-employment drug test, we can no longer test for any of the metabolated use of marijuana. In other words, only the active THC should be considered in reviewing whether a person is eligible for employment. There are exceptions to this in construction trades and in other trades where federally mandated background checks are required. And so if you have any questions regarding this, certainly you can talk to your background and investigation company. You can talk to us as an HR representative or your employment attorney regarding your hiring practices in marijuana. All right, so now that we've hired the person, we want to onboard them. There's a couple new requirements having to do with onboarding. Hopefully we're all aware of the increased paid sick leave, and I'm going to cover that in just a minute if you're not. But in line with that, we are now required to update our noticed employees, which is the 2810.5 form. It has new language regarding the new requirements for enhanced sick leave of 5 days or up to 5 days of time off. It also has information regarding disclosure of emergency declaration. So if your company is under a current emergency declaration, we're required to notify employees through the 2810.5. So the options are provided on the 2810.5 to tell employees what kind of sick leave policy that you have. You're allowed to have an accrual of 1 hour in every 30 hours worked. You can also upfront or load upfront 40 hours worth of sick pay into an employee's sort of coffer or bucket of sick pay. And there's some other accrual options as well. Sick leave accrual policies require that employees receive 24 hours of sick leave accrual within 120 days, and that they have 40 hours of sick leave accrual within 200 days. So if you don't use the 1 hour in 30 hours worked, you want to make sure that your sick leave accrual meets those regulations. The form also includes information regarding workers' compensation, carrier, contact information for the employee should they need that. In addition to providing this form to your new employees at onboarding, you also want to update your current existing non-exempt employees. The non-exempt employees that you currently have should be provided this form. If you haven't done that yet, you want to do that as soon as possible. And they would each receive that, including their new overtime rate, which is included on the form, emergency declaration information, and the current sick leave policy information. All right, let's talk about safety. So not all employers, especially small ones, are aware that in California, we have the CALOSHA safety requirements. CALOSHA is the state form of our federal OSHA program. And in California, we require that all employers have an injury and illness prevention program, or IIPP. An IIPP consists of an identification of your office and or industry hazards, provides mitigation plans such as training or procedures and improvements needed. And it also has provisions for the documentation of safety records. That includes injuries and other things. So if you don't have an IIPP, there's a couple things you can do. One is that you can contact us if you'd like to do that. You could also talk to your workers' comp carrier or broker. Sometimes they have forms, as well as checking out the CalOSHA templates, which they do have available online. So a couple of new things have come up in these requirements for IIPP. One is that in 2023, we recognize the emergency of COVID is over, but there's new non-emergency program requirements for COVID. You can actually do this as a standalone policy, but it's also quite appropriate to put this within your IIP document. We also have a new requirement, which is the SB 553. It's a new section for workplace violence prevention. This should be included in your IIPP, and it's a very important topic these days. Sometimes obviously workplace violence comes in different forms. It could start with a complaint from a customer. It can start with a grievance of an employee, and or maybe an outside force like a domestic violence situation that's coming into the office space. With that requirement for the workplace violence prevention, which is due by July 1st of this year, there's also the SB 428, which now expands employers' scope or allowable scope to obtain a temporary restraining order in response to a workplace violence concern. So if you have an issue going on that includes workplace violence, you want to consider a TRO, it is a good idea at that point to reach out to an employment attorney regarding those options. Okay, so it wouldn't be California if we didn't have new leave enhancements to discuss, and this is certainly no exception this year. So as I talked about before, we do have some new rules regarding sick leave, and I'll go over those in a moment. But we also have a new leave program, which is a reproductive loss program. The reproductive loss program is for every employer with 5 or more employees, they need to provide up to 5 days of unpaid leave for the loss of a pregnancy, loss of an adoption, or other reproductive related losses. It's akin to bereavement. It's not quite the same as that. It also protects employees from termination or discrimination, retaliation for exercising the rights of reproductive loss or other reproductive issues. And so if you have any questions about that, just let us know. I look forward to those. So in addition to the reproductive loss, in 2023, bereavement was also improved, and it's now 5 days of unpaid leave within 3 months of the event. This is an increase from 3 days in the prior legislation. So if you haven't updated your employee handbooks or other policies, it would be a good time to do that now. And as we discussed, there's some California sick leave pay changes. We now have 5 days or up to 5 days of California paid sick leave, and I'm going to talk about that a little bit more. I know we have a lot of topics here, so we'll keep going. So in 2024, an employee is allowed up to 5 days of equivalent sick leave, and that's paid. Employees who have worked for at least 30 days for the same employer are eligible for that. And that includes really any classification of employee that's worked more than 30 days. So it's important that we start to redefine what seasonal and part-time employees are, that they do have sick leave benefits. And that may not be the same in terms of other benefits that you offer part-time that you only offer to full-time employees. So it could require that you update your policies regarding that. So the minimum accrual amount of 1 hour of sick leave for every 30 hours worked, or as I mentioned, we can offer a front-loaded minimum of 40 hours for each year at the first of the year. That year can be defined as a calendar year, it can be defined as a fiscal year, but whatever it is, we need to let employees know what that is. And, there's no payment at termination for sick leave, unlike PTO or vacation time, which you do need to pay out to employees if they happen to leave. However, I'll bring up, if you do combine your sick leave with PTO, you can't subtract the amount that they've taken for quote unquote sick leave from the PTO and pay them less. You should pay them out at termination for the full amount of the PTO or vacation. Let's talk meal and rest period breaks. So this is a complicated issue and one that I want to bring up. It's tough to calculate meal and rest breaks. All employers should be considering their employee shifts and whether or not they should be providing meal and rest breaks. If they work 3.5 hours or more, they need a 10-minute rest break. If they work 6 hours, they need to have a meal break, which is an uninterrupted period, unpaid and clocked out break. They're allowed to leave the offices if they want to, and they have some control over their own time during that 30 minutes. If they're interrupted during their meal break, they need to be given another one, and it could cause some issues and some penalties, and we'll talk about that in a moment. In addition, there are waivers allowed for 6-hour shifts, but as soon as you go over 6 hours, the waiver is not allowed. And so you want to be mindful of the schedules and how you're scheduling people, that they actually do get that meal break within a 5th hour or 4 hours and 59 minutes that they clock out. If they have a waiver and they don't work more than 6 hours, that's fine. If they do work more than 6 hours, even with the waiver, you could be facing a penalty. So, like I said, employees must be allowed to have an uninterrupted meal break off premises. They're unpaid. They must record their time, and this is important. If they don't record your time, you are at liability then, because you have nothing that indicates whether you've held them accountable to that meal break, and it could cause some issues in terms of penalties if the employer or the employee later comes back and says, I didn't really take my breaks and they didn't make me clock out for them, so they can't prove that I took them. So that's just one thing I want to bring up. I've noticed that a lot of employees don't like their employees to clock in and out. They feel like they want to trust them to do the clocking in and out, but this is a requirement of this particular regulation. Okay, so that's for non-exempt employees. Exempt employees, it's assumed that they will take the break and they do not need to clock in and out. No meal break and no waiver equals a penalty pay. So what does that mean? If your employee does not take their meal break and they work more than 6 hours, you are then liable for a 1 hour at regular rate penalty pay that is added into their regular paycheck. And if you don't either give them the break or the penalty pay, then you're opening yourselves up to fees for not following the regulation, as well as penalties and interest for unpaid wages. So this is really important. And if you need more assistance in understanding the meal and rest period, I would call and talk to a representative that can help you kind of understand this a little bit better to make sure that we're taking care of ourselves and our employees and avoiding penalties. I just love this picture. It's really, really cool picture. But that brings us to talking about some of the changes of overtime and agricultural workers in particular. Hopefully you all know that there have been some changes to the overtime rates for agricultural workers, but I'm throwing this one out there just in case people aren't getting that news. AB 1066 was enacted in 2016, so this has been going on for quite some time. We're trying to bring agricultural workers up to the same wage and hour rules as other industries. So as of January 1, 2024, you should be paying your agricultural workers overtime rate at 1.5 times the regular rate for any day worked over 8.5 hours or a work week over 45 hours. By January 1 of 2025, you'll find that their overtime pay should be the same as any other industry overtime pay, which is the $8.40. Overtime should be paid at hours worked over 8 and hours worked over 40. Some of our clients are moving to alternative work schedules to better take advantage of the work and have folks out on the field without having to do quite so many shift changes. And so this is important to note. If you do decide to go to an alternative work schedule, you want to also make sure that you go through the process of doing that correctly. There is a voting process and a documentation process for alternative work schedules. I'll also note that the location matters in terms of where people are working. If an employee is working in a location where a local ordinance has a higher minimum wage, they should be paid at the higher minimum wage. This also impacts their overtime rate, and you may need to blend the overtime rate. And I use the city of Santa Rosa as an example of that. If you've got a location where there is agriculture within a city limits, that wage ordinance for minimum wage may be higher than that in unincorporated area or in another city. So finally, I want to talk a little bit about confidentiality and the right to speech within the workplace. Confidentiality, obviously, and privacy and the right to speech, they're all obviously really big topics right now in politics, employment, and in our personal lives. In addition to the regulations regarding protection of data and privacy of our employees and consumers, we must now also be mindful of our attempts to limit an employee's right to speech when it regards their employment environment, including their wages. So confidentiality policies and agreements really should be limited to trade secrets, client information, employee privacy information, or other proprietary information, and not in turn about their own experience as a worker or their wages or anything else. In addition to confidentiality agreements and language within our documents, there's also been some pretty big changes to non-compete agreements. A non-compete agreement is an agreement that limits a person's ability to leave a job of a specific kind and go work for a competitor. Those now are pretty much unenforceable in California, and in fact are void even out of state if the employers within California. So it's our recommendation at this time that if you have confidentiality or non-disclosure agreements, non-compete agreements, that you have those reviewed by a professional and make the changes that are needed also in your handbooks or other policy documents. You know, what is confidential? Again, confidentiality includes trade secrets, includes client information, proprietary information regarding your company practices. It does not include the employee's wages. It does not include their feelings about their work environment. And if you have questions about that, seek some help. And then non-competes are void now, even if they're out of state. So finally, I just have a few suggestions to review your policies this year if you haven't done that in a while. To reiterate what I've said, all proprietary and confidential agreements is a good time to look those over, as well as your handbook and other policies. I also suggest taking a look at your code of conduct and professional conduct documents or policies. In line with discriminatory practices, some of the changes in the laws regarding the marijuana use off-duty and other off-duty kind of activities, including confidentiality, those might need to be reviewed. Provide some training, if you haven't done that in a while, to your supervisors and managers regarding overtime, paid sick leave, and meal and rest breaks. These are all important topics that can lead to extensive liability if not done correctly, or if time is not approved correctly on a time card, meal breaks are not provided. So it's a good time to take a look at that. And, finally, update your handbook. If you can't do that every year, if it's cost prohibitive or time prohibitive, I do recommend every 2 to 3 years, or at least have some practice of looking at those large legislation items and putting an addendum to your handbook. And if you have any questions or concerns about that, please feel free to reach out to me or to your own internal folks, as well as an employment attorney, if it's something you'd like to do. So updating the handbook right now, I would recommend the confidentiality, bereavement, reproductive loss, paid sick leave, really all of the things that I've mentioned above, I would consider in your handbook as an update for this year. So I want to thank you, and I'm looking forward to your questions. And I hope this presentation has been very helpful. Thank you.
Trish, thank you. That was really good, very informative. Honestly, a little bit overwhelming when you start to look at all of the changes that and updates that need to be made. Most of the folks in our audience are pretty small businesses, small wineries, small vineyard operations. Tell us a little bit about how personal perspective can help make it a little bit easier to get your handbook up to date, make sure that you've got the right forms, not only for new employees, but for existing employees to ensure that you stay in compliance.
Thank you. Thank you so much for asking that question. I really appreciate it. And our hope is that Personnel Perspective would be able to help you pretty much with any of your policy updates or questions with any of these topics. So in terms of a handbook update, we also can help write and create brand new handbooks if that's something you're interested in. And certainly a lot of our smaller employers need help with this. It's not unusual. We also can help with the development of IIPPs and safety programs. In addition, we do policies one at a time. So if that's something that's more feasible for you than looking at a whole set of policies, we can start you out with those that are the most important to you. Another thing I think I'd like to mention is a service that is called an HR audit or an HR review. It's something that we do with employers that maybe have been going for a while and don't have an internal HR person. And we review your practices, procedures, and all your documents, and then come up with kind of a recommendation list and findings of things that you might need to do to bring yourselves up to that next level of HR compliance as well as sophistication within your company. So that's a really great service. And it's one that I really love because it shows that our employers are interested in providing a great workplace for their employees.
Well, I definitely encourage, anyone in the audience who maybe have some questions about whether or not their handbooks, their guidelines are up to date, to reach out to Trish or the gang over at Personal Perspective. We actually work with them very closely. In fact, we recently had a harassment training that I think we need to or required to do every couple of years. So it just makes your life a little bit easier and lets you focus on growing better grapes, making better wine, and hopefully selling more of it every day. So thanks again, Trish, for your time. Once again, I want to thank everyone in our audience for joining us. And least, but certainly not least, I want to thank all of our sponsors again for their support. We'll see you soon.